Today is Thursday, and like we said, Thursdays we want to have conversations about accessing justice. It's hashtag Justice Thursday. And we've been having judicial officers and people who work in the judiciary coming. Soon we're going to open it up as well and have talk to people who are seeking justice from various courts in the country, just to understand. So what do we need to do for all of us to make sure that we have good justice? Our guest is a judge of the Court of Appeal, who is also the chair of the Administration of Justice and Performance Management Committee, the Honorable Justice Agnes Murgor. Welcome to the Situation Room.
Thank you. Thank you so much, Eric. Thank you for having me here this morning. I am very excited. It's always great to talk about performance management in the judiciary.
It's also very good for us because we are now the ones who are up there on the bench. You're down there. Okay? That is the hot seat. We ask the questions. My lady, you answer the questions.
To the best of my ability.
Justice, don't let this man scare you.
It's power.
This entire episode will be just one pleasant conversation, and at the end of it, you'll be wondering how quickly the hour has gone by.
Said the spider to the fly.
Well, as long as we're talking performance, I'm happy to be here.
Great. So we will be talking about the performance, like you said, what this whole issue of performance management in the judiciary is all about. But as we've been having guests from the judiciary lately, we've been wanting to understand them as a person and then the work that they do and the experience that they've had in dispensing and giving access to justice for Kenyans. Justice Murgor, you grew up in a lawyer's household. You live in a lawyer's household, you know. This has been your life. It's like you were meant to be where you are.
Harry, you forgot one bit. Your leadership, you are also a lawyer.
Absolutely.
Yes.
Absolutely.
All your life, you only know lawyers.
Well, if you looked into my background a little bit, there's a lot of other things that I've been doing as well.
Yes.
But insofar as the legal profession, insofar as law and justice is concerned, it's an area which I'm very comfortable in, and it's an area which I've seen evolve tremendously over the last so many years, especially since the promulgation of the 2010 Constitution. And therefore, from the way we used to practice and the way we would litigate in the courts, to a very great extent has changed, because now we are required to ensure that cases are heard and determined, and that advocates don't file their cases in the courts, and so that the court becomes a store for files that have been sitting there for years and years and years. So since the promulgation of the Constitution, the judiciary has changed to a very great extent, and a lot of measures have been put in place to ensure that justice is expedited, that cases are heard and determined, and instead of cases sitting around for years, we're hoping that we can finally get to the point where we can say that a case will be heard and determined in not more than 2 years. So that's what we're aiming for. We have a caseload in the courts right now where some of the cases exceed 5 years. We're quickly trying to bring that down, where we're saying cases older than 5 years must be determined. They must be cleared out of the backlog, and so that we can focus on current cases. You can imagine hearing a case that is so old in the works that even the parties are no longer there.
Yeah.
The lawyers are no longer there. And I'll let you in on something, that before when we instituted performance management, we had to do an audit of the many court registries around the country. And you'll be surprised that we had case going back to 1939 sitting in the registry, simply because it had not been heard, and many of the parties involved just had passed on. Well, you can imagine 1939, the parties had passed on, the advocates had passed on. It was just one of those old cases. Anyway, it was eventually called out and disposed of in the way that it should have been disposed of. But yeah, these are the sort of things that happen. And if you don't regularly go through the systems to ensure that you're bringing up cases, having them heard and disposed of, parties and justice will be denied to many a Kenyan.
Right. It seems that the issue of the time that is spent on cases is a major bone of contention. Would you say, I mean, just from what you're saying then, the adjudication of cases then in a shorter period of time, getting them cleared out of the system, would that then be an indicator of positive performance for the judiciary?
Oh, absolutely. Under performance management, what we have tried to introduce is a process whereby from the date of filing until the date a case is resolved, we're able to track that performance. We have a template called the Daily Court Returns template, where courts on a daily basis input every single activity that might be happening on a given file and in the different courts. So you're able to track a case from the moment it's filed, how many times it's come to court, how many adjournments, now that word adjournments, don't let me forget that, how many adjournments have happened to that case, when it finally came for hearing, when the witnesses testified, when it was finally determined, and eventually when the judgment was written and delivered. So what you find is that in many cases, they get held up in court because of what we call adjournments. Adjournments are when maybe the court will adjourn for a particular reason, or advocates come to court and say that they're not ready to proceed, and so the case doesn't take off that day, or they just basically don't show up, or the witnesses in a case don't show up. So because of the number of times the cases keep coming up for hearing, you will find that the cases delay. And as they delay, it just means that, we're not getting any closer to finalizing that case. And that is where the biggest problem is. These delays from the time it's filed until it's eventually concluded.
Sorry, please go ahead.
And if I could just wind up that point and say that what you will find, and, for my fellow colleagues out there in the legal profession, our statistics do show that any cases that involve advocates, involve legal counsel, those ones tend to be the longest to be concluded at the end of the day. And I'm sure you've heard my colleagues say this as they have come onto this show. In many cases, we look at our data, you will find that criminal matters are concluded very quickly, particularly where there are no counsel. Civil cases are where we have the biggest problem. They just never seem to come to an end.
You've actually touched on what I wanted to ask you. I'm sure with time and with the understanding of the situation, you must have collected data as to what it is that could comprise a body of culprits that cause these delays. What are they?
Well, actually, you're absolutely right on that. We've been tracking what we call adjournments, and we have data that shows the kind of reasons that come up for adjournments. So you will find let's look at it from the civil case perspective, you will find advocates not ready to proceed. Maybe the court had to adjourn on its own motion for one reason or another. Witnesses didn't show up, submissions have not been filed, case cannot proceed, all manner of reasons. When it comes to criminal cases, maybe the accused person was not brought to court, or the prosecution's not ready to proceed, or the lawyers are not ready to proceed that day, or there are all manner of reasons, but it would usually turn on the parties and sometimes on the court as to who's ready to proceed on a given day. And you'll find when parties are really not anxious to proceed, there's every single reason in the book that they will find to ensure that they don't proceed.
Justice, beyond adjourning, what powers do our laws give justices like yourself to intervene in such cases when you can clearly see the path that is being beaten before you, and you can see this is where these people want us to go, and you know this is what we ought to do?
There are various mechanisms that can be employed, but it always will suit the circumstances of each case. Where you find there are far too many adjournments, a court will say last adjournment, and then sometimes if the reason is very good, the last adjournment will be allowed to go into another last adjournment. So ultimately, in the end, it has to come to an end. And therefore, the court will say it will proceed and give the parties the option to proceed with the court. And if they're not willing to proceed, the court will say, well, if one party is ready, we will be taking off today. And I can speak for my court. We have a no adjournment policy where we say, if you're coming to the Court of Appeal, you must be ready to proceed. And in many cases, if parties are not ready to proceed and they don't have a good reason, we'll give them two options. We'll say to them, you either proceed with your appeal because we're here, we're not going anywhere, and we're very ready to hear you. Or if you're not ready to proceed, then you have the option of also withdrawing the case if, you don't think your case is good enough to proceed in the appeal. So if those are your two options, likely than not, if you have a good case, you will say, we will proceed in 10, 20 minutes.
Right.
Let's get our act together and we can then have the appeal take off. But you find that in most cases, there's been always the question of whether there are hearing dates. Many times you hear, there's no hearing dates, the diary is closed, and, there's a lot of issues around that. But my looking at the different courts around the country, because under performance management, we do go and actually visit courts, see what's going on. You'll find that the dates are there. They give dates all the time for hearing of matters. The only problem is, are hearings taking off on that particular day? So these are the issues, those are the kind of issues we have to deal with. And, it really, to a very great extent, depends on the circumstances of each individual case.
So basically what I'm hearing you say, Judge, is that very many of the reasons why cases are not proceeding on time is because people are trying to game the system.
What you would actually say is that there was a time, and I guess this is a mode that we're trying to get out of now, where you would tell your opponent, if you were a litigant, I'll see you in court. And when we then meet in court, we can hold up the matter in court for as long as we can so that, you'll see who has the power here.
Yeah.
And like you say, it does become a power trip. And for us who sit in the courts and, trying to ensure that we are dispensing justice, it is so important to ensure we don't get involved in that game. Ours is to ensure that at the end of the day, whoever has come to court gets the justice that they deserve.
We hear of alternate resolution mechanisms within the judicial system, mediation, arbitration. Now, at the level of the Court of Appeal, does it work?
So far, not. So far, it hasn't been introduced at our level. I think we look at it from the premises at the moment, and that's not to say we'll rule it out altogether. But we're looking at it from the premises that if the parties all along have not resolved their disputes up to this particular point in time, chances are at our level we're not going to get to that point. In many cases, though, I must say, we have said to parties while we're sitting in court, have you tried to resolve this particular issue even at this level? And in some cases, the parties have gone away and come back and said, yes, we've been able to reach a settlement where we're ready to withdraw our appeal. So we don't rule it out. It's just that it doesn't happen as often as it would at the lower levels of the judicial hierarchy.
Let's take a break at this point, and then we can continue the conversation after this quick break. It's coming up to 25 minutes after 8. This is Kenya's biggest conversation, The Situation Room on SpiceFM, on KTN Home, and we are live streaming the show online. With us in the studio this morning, Justice Thursday, is the Honorable Justice Agnes Murgor. She is the Judge of Appeal and Chair on the Committee of Administration of Justice and Performance Management. We are discussing performance management in the judiciary and what work they are doing to ensure that there is speedy resolution of cases that end up in the justice system. We are back with the conversation this morning in the Situation Room with Eric Latif, CT Muga Nduoko, and the Honorable Justice Agnes Murgor of the Court of Appeal, who is also the Chair of the Committee on Administration of Justice and Performance Management. Judge, before we took the break, you were telling us about the performance management and what you've done. You first started by doing an audit and seeing where are we, establishing where you are, and then setting in motion systems that would make sure that you then are able to track what's happening across the entire justice system. So what is this performance management and how do you do it?
So thank you, Eric. Let me take us back just a little bit to
Yeah.
give us some background as to how we ended up with the performance management in the judiciary. In 2013, the former Chief Justice, Willie Mutunga, set up a committee to look into institutionalizing performance management in the judiciary. And this committee was comprised of judges, magistrates, registrars, direct representatives of the directorates, and we formed the committee together with the Directorate of Performance Management, which is a directorate that is housed in the judiciary. This committee then looked at what would be the best performance management system for the judiciary, because being a very unique entity, an institution on its own, you couldn't track performance in the way you would a private limited company or a corporate or even the executive. We had to come up with our own system that would suit the way in which courts do their work. So after we did, as a committee, a lot of benchmarking, desk research, we went to the US and to Australia to see some of the systems and how they're functioning there. We were able to come up with a performance management system that would work for our specific judiciary, taking into account at the time that our backlog, and I'm not even so sure that we had accurate numbers, was about 1 million cases sitting in various registries around the judiciary. So what we found is that there is what is called the International Framework for Court Excellence, and that sets out various measures by which courts can be measured, as can be judges, judicial officers, directorates, which are associated with courts, administrative units, tribunals, registries. The whole works can be measured. And these measurements basically are, insofar as access to justice is concerned, expeditious disposal of cases, trial date certainty, case clearance rate, backlog. I mean, there are a whole lot of numbers that we're able to track. But before we could get to this place, what we needed to ensure is that we're able to see cases being filed in the system and cases that are leaving the system. And then within that, all the different activities that happen to cases as they're within the court system. So that a file cannot be allowed to sit in the system for longer than it need be, unless it's one of those cases where the parties are just too many, and there are just too many issues that keep coming up in the life of that case. So from what we then put in place is a template called the Daily Court Returns Template. And in every single court around the country, that template will tell you what is being filed in any given court, what are the activities, and it's all loaded into the system on a daily basis. This is then collated and submitted to the Directorate of Performance Management as monthly data. So by the 5th of every month, this data must be in, and it must be submitted in the most accurate form possible. Because remember, this is data that is coming in from all courts and institutions or the various different administrative units around the country. And this is information that is not only used judiciary-wide, it's actually statistics that are used countrywide, and we even found globally to a certain extent. So this data has to be accurate. It's put into the system, and the Directorate of Performance Management will then ensure that it's collated into a format that now we can read and understand. So you will find that in performance management, when a case is filed, when it is cleared, we can tell you that in a year. We can tell you what the backlog is. We can tell you at any given point in time how many cases across the country are sitting in the judiciary. So as of now, we probably have about 650,000 cases, all told, sitting in all the different courts around the judiciary. That information is available at our fingertips. Before, it was not available at all. And if we were ever asked how many cases are sitting across all courts, the number would range maybe from 800,000 to 1.2 million. I mean, there was no certain amount. Today, we can say as of fact that there are X number of cases actually sitting in the judiciary. So because of that, you're able to budget, you're able to plan. And so this is what we do as in a year. We plan using our strategic plans, work plans, sign up the courts to what we call performance management understandings. And those understandings will give the different targets that each court, and remember, courts are different around the country. They do the same work, but depending on their size, they have to be evaluated differently. So, for example, you can't evaluate Lamu Court in the same way as you would Milimani Court, because Milimani, they file thousands of cases, whereas in Lamu, perhaps their caseload would be anything from 200 to 500 cases in a year. So the number of cases also would vary. You would plan according to how many judicial officers, for example, would be posted in a given court station. So going back to our Lamu example, you couldn't have more than 2 or even 3 magistrates sitting there because of the caseload. In Milimani, there are a whole lot more because of the number of cases that are filed there. So these are the kind of things that you would be able to use your data and statistics to able to plan, monitor, and evaluate what's really going on. And under the performance understandings, we actually are able to, in the initial stages, we couldn't do this because we didn't have sufficient data. We couldn't tell you what a court, the case clearance rate for a given court was. Today, we can tell you exactly what the case clearance rate for any court is around the country at the end of each financial year. So that you're able to see what the flow is of cases being filed, and what we calculate case clearance rate as number of cases filed versus the number of cases leaving the system. So if you have an equal number filed versus what leaves, that's 100% clearance. That court is not going to create a backlog simply because it's clearing everything that's being filed. Now, if you file anything less, you create a backlog. If you file more, you eat into your backlog.
Does the performance management take into consideration capacity of the system, judicial officers. It's been an issue in terms of funding throughout the system. So does it take into consideration then what is needed to get the job done vis-a-vis the number of cases that are coming in and out of the system?
Absolutely, absolutely. In fact, the performance management system has been very revolutionary for the judiciary. It has helped us determine what number of judges or magistrates are needed to resolve the number of cases that continue to be filed. The recent appointments of the judges took into account that we have many land cases around the country, and they take a very long time in many cases to be resolved because land is a very emotive issue.
Yeah.
And you need to ensure that the parties are heard and that the issues are resolved in the best way that they should be resolved. So we had very few land judges, environment and land court judges. And also the other pressing issue were the Employment and Labor Relations Court judges. Because today there are so many employment matters that continue to be filed across the country for various different reasons. So whereas in the past we would have always employed High Court judges, this time around the thrust was to ensure that where the need needed to be addressed were the judges that needed to be appointed. So we more land court judges and employment court judges were appointed this time around, and happily they've been assigned to different courts around the country. Some are very new courts for the simple reason that we've never had environment or employment and labor relations courts in some of these court stations, and because of that now we have them. They're able to deal with the issues on the ground in those particular areas where they've been assigned. So yes, it has gone a long way towards assisting the judiciary, the Judicial Service Commission, to determine where the need is and how to address it. It helps from a budgetary perspective as well, because when we say we have a caseload of X, it also means we need so many courts, because you cannot have judges who don't, or magistrates who don't have courts. So you need court infrastructure, and court infrastructure comes with court registries. Court registries must be staffed, and those staff have to have chairs to sit on, and it's a whole spiral thing.
Yeah.
So that at the end of it, all of this comes out of planning with the caseloads that we have sitting in different courts around the country. And you've heard the Chief Justice, Martha Koome, talk many times about access to justice from distance to courts. You find that where litigants are not able to find their way to courts, they find their own kinyumbani way of resolving their problems or alternative dispute resolution. Sometimes this is not always very good, because one party will end up being unsatisfied with the way in which the case was resolved. So that we need to bring justice closer to the people. Performance management, to a very great extent, has been able to help budgeting, planning, and ensuring that we can achieve the objectives, which is to dispense justice to the people of Kenya.
On that note, dispensing justice. When you talk of being facilitated or having adequate resources, finances notwithstanding, judicial officials like yourself in the Court of Appeal, in the lower courts, are you staffed with adequate personnel who support your work with the research capacity that is necessary? Because if we're talking about access to justice, research would play a very critical role in it.
You're so right about that. And this is where we say that our Judicial Service Commission in the last year or two has worked extremely hard to ensure that the legal requirement in law that each judge has a legal researcher has been fulfilled to a very large extent. So they have undertaken interviews to recruit legal researchers. And so we have legal researchers who help with the work that we do. And the caseload, just to be able to get through the amount that we have to do, because face it or not, we still need more judges. We still need the numbers to be able to cater for the number of cases that continue to be filed. And therefore, you need the extra help to help you do the research so that you're not spending hours doing all the research and also trying to write your judgment at the same time. So it helps. All of that really, all told, when you put that all together, it certainly helps. But I must say this, if we're talking about staff, we still need sufficient staff across the judiciary. We still need, if you go to many registries, they are understaffed. Many courts still need the extra support from different staff cadres across the board, accountants, procurement officers, and so on. And without them, we will not be able to operate optimally. We're doing our best. The judiciary is trying its very hardest. But yes, with these kind of shortcomings, that is the kind of thing that need to be taken into account to ensure that, the courts at all levels are working at full capacity.
As a
How
senior
are you working? Sorry,
Go
Siti.
ahead.
How are you working so far? So you've done all this background work and the research, and you know the picture of the judiciary as it is today versus the needs. So in terms of judges and going down all the way to the other cadres of staff, how are you operating? Are you at 60% when it comes to, the number of judges required to meet this caseload, the number of researchers required, the number of other admin and support staff required? What percentage would you say you are operating at?
I would say that we probably have, at the staff levels, maybe 20 to 40% deficit. I would say for it's you need to break it down into the different categories.
Yeah.
So like for magistrates, I think we're doing pretty well on that. We've just recruited resident magistrates, about 50 of them, that have been deployed to different courts around the country, and that will help a whole lot. But there's still a deficit among the magistracy. Within the High Court and the Court of Appeal, I will say we still need judges. I can't try to dictate the figure, because if I do...
What percentage of deficit from what you have now in terms of the caseload in the Court of Appeal versus the number of judges in the Court of Appeal?
Well, first of all, I would say that our statute only allows us up to 30 judges in the Court of Appeal. I think our number now is probably about 28 in number, if I'm correct. And colleagues, forgive me if I'm wrong. But so that's...
But you're not 30.
We're not 30.
Okay.
We're not the full number of 30 as yet. But the truth of the matter is, even at 30 judges, we did a rough calculation the other day, and we said if we had 30 judges trying to complete 8,000 outstanding cases right now, do the mathematics, how long will that take to complete all of those cases if we don't file any new cases in our court? So the number for the Court of Appeal is low, but because it is statutorily set, I can't say what the percentage would be. For the High Court, I think that, for the High Court and the courts of equal status, so that would be the Environment and Land Court and the Employment and Labor Relations Court. I would say that maybe we need another 40% to be able to deal with the numbers of cases that are being filed, and looking at the number of cases being filed across the board, because they are wide, they are varied, and they're in the different courts. But looking at the whole situation, I think we will get to the point where we will peak on the number of cases being filed in court, simply because what we are looking at today is very historical. It's going back to clearing backlogs coming from, 5 years and over.
Right.
So that we will reach a peak, that's my wager, that we will then be able to manage the caseloads that are in existence, because we will now become current. And we're looking to becoming current in the next 2 years, and we will be able to say, and this is very optimistic, but we'll be able to say that no case in the court more than 2 years, or 2 or 3 years.
Justice,
maximum.
here you are in your office, in your workspace. A normal day, when culprits have been brought before you with the many issues that you're required to resolve, to the end of that particular chain of events where you resolve them, what occupies most of your time?
Well, the hearing of cases.
Okay, that's one.
When you look at cause lists of courts around the country, sometimes those cause lists will go up to 40 cases when we're dealing with what we call mentions, applications, hearings, and, all the various things that are included in a cause list. So hearing and just disposing of matters in the cause list takes up the biggest part of your day. The next part of your day is writing. So you're always writing. You've got something cooking in your head all the time, which you need to be writing.
Right.
So writing takes up the next big chunk of what you do. And you will hear many judges and magistrates tell you that their work or their cases never leave them. We call it carrying people along with us, because whatever case you might be writing relates to people.
Yep.
So we carry people along, depending on what we might be writing about at any given point in time. So yes, that's the next big thing that would take up a judge's or magistrate's day.
Now my question. How would technology help ease this burden, if it can?
Well, to a large extent, we in the court or in the judiciary say that COVID was a blessing in disguise, because it helped us to tip over the balance of what we needed to do to ensure that the courts could become more technology savvy. That was something that was always a pipe dream. We never believed it would actually happen. But suddenly COVID came along and we all went virtual.
Right.
And we were all hearing cases virtually.
Yeah.
And the truth of the matter is, because of the different devices or the different techniques that you're able to adopt with virtual calls, one of the things that judges, magistrates will tell you is we used to writing and writing and writing. Now we get recordings coming off the virtual platforms, and we can have our submissions and whatever else right there without having to write long submissions or long cases. So that it has helped to a huge extent. And it even during the COVID time, we could honestly say that courts did not shut down, simply because we could hear cases virtually, and especially urgent matters. Urgent matters could be heard, and therefore, we were able to continue to dispense justice. And truth be told, I think that the virtual operation is very far from being something that we will do away with. I think that for long hearings, long cases, those will continue physically. But for short applications, for courts like mine, where we rely on the record And on submissions, we could very easily proceed to continue our lives having virtual hearings.
And so from a performance management perspective, would it be something then that you would then suggest or then inculcate into practice? Because we did hear Chief Justice say that, all right, everybody now, back into the courts, even after this whole virtual stint that we had. But then looking at what you're saying now and saying that, look, in the near future, we're hoping to have, dispensed and done away with all of these cases and move into this 2-year cycle. Would you then not see the introduction of virtual cases, for example, to aid in this?
In fact, the way I would see it, I would say that virtual matters will be dealt with, or rather, we will have cases being heard on a hybrid, from a hybrid perspective, so that we would have virtual matters being disposed of in the way of applications or short submissions, things that can be heard virtually and which don't pose challenges for parties. But on the other hand, there will be physical hearings. And remember, not all courts can be virtual. Not all courts have access to Wi-Fi or electricity. We still have courts where electricity is a huge challenge. And so they're not able to operate virtually. So we have to balance it out. We have to be able to ensure that we're not cutting anybody out from accessing justice. And so I see going forward a very mixed way, a mixed grill way of operating as courts, so that we would be able to do the two. And incidentally, for our court, I think we had more cases virtually than we did physically. And simply because we, as I say, we have a no adjournment policy. But when the cases did come up for hearing, they proceeded. We heard them. And all we did was sit down and write judgments. We've never written so many judgments in our lives before because of the number of cases that we were hearing and were not being adjourned.
Right.
So it's an exciting time, I think. And if we build on this, we can only improve the performance of courts.
Justice Murgor, as we wind up the conversation, what message would you like to give Kenyans who are listening to this and are following this conversation in terms of accessing justice? There are those that are facing one matter or another in court, or they have a relative or close friend who's facing one matter or another in court, and maybe they're sitting there frustrated, wondering, it's been so long, so many years since this matter first went to court, and I'm wondering when it's going to come to an end. What would you tell them?
I would say to our consumers of judicial services, don't despair, don't be discouraged. Simply because your case in one form or another continues to be tracked. It is known, it exists in the court system. And therefore, we're able to track and see how long cases are actually taking in court. So that what I would encourage is be persistent, be insistent on having your case heard. Make sure that if you have an advocate, that you follow your advocate to ensure that there is no adjournment of your matter, that it proceeds on the day that it has been scheduled for hearing. It is so critical, it is so important that we work together. We always want to hear feedback from our customers, our consumers of justice. If there are issues, you should get in touch with the judiciary and state where your problems may be. We are always open to hearing from you, your suggestions on how we can improve our services, how we can ensure that we serve you better, serve Wanjiko better, and ensure that all consumers of our justice reach the end of their cases. So those days are with us. And continue to support the courts, because the courts need all the support they can get from those who are seeking justice.
Asante sana. Justice Agnes Murgor from the Court of Appeal, who also chairs the Committee on Administration of Justice and Performance Management, has been our guest in the Situation Room this Justice Thursday. Thank you for joining us and coming to us today.
Thank you so much for having us.